Our next case is Brian Hoffman versus Upikin Gunawan. Did I pronounce that correctly?
That's correct.
Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims during the argument, and you should refer to them like terms like the child or initials. We have read your briefs and are ready to proceed when you are.
Good morning, Your Honors. May it please the court, my name is Brian Hoffman and I am the pro se plaintiff in this litigation. Don't stand up for abused kids in Wayne County. That is the message that institutions have been sending to me, the plaintiff in this case, since the initiation of this litigation. This is a case...
But doesn't standing up for abused children mean you make a report to the proper authorities?
Yes, and I was going to bring that up later, but the trial court in this case made two observations. One is that we should have gone to Children's Services with these concerns, and the other is that the premature or immediate filing of this litigation did more harm than good. In fact, I did file a report with Children's Services, as did a variety of other people. There were affidavits in I believe it was our opposition to the defendant's summary judgment motion that explained that there was an active Children's Services investigation. As to the timing of the filing, the affidavits also established that we contacted the Ohio Office of Disciplinary Counsel, we contacted other attorneys who specialize in representing children, and we made a variety of inquiries before initiating any litigation in this matter. So for the...
Okay, so the affidavits that you submitted in regard to the summary judgment, did they include the timing of in regard to when that was reported to CSB? Was it before or after the suit was filed?
I believe the specific paragraph says prior to the initiation of litigation in this matter.
Okay. And so would that have been, if you recall, prior to the time mother had asked you to stay away from her child?
I believe it was prior to that time, Your Honor. I would have to look more carefully at the precise affidavits. But in this case, the affidavits also established that the defendant was the only source of derogatory information against me, and that despite that fact, I was suspended, replaced, and had a grievance filed against me with the Ohio Supreme Court. So we're before this court on the trial court summary judgment decision, which is based on whether a genuine issue of material fact exists. And here there are several genuine issues of material fact that the trial court overlooked. One is that the trial court never disposed of our tortious interference with contract claims or our intentional infliction of emotional distress claims. And even if the trial court's view that any statements made by the defendant were just her opinion is correct, that also doesn't dispose of our defamation per quad claim, which can be proven based on the context in which the statements were made. So most of the allegations in the pleadings were actually denied by the plaintiff and the defendant back and forth, and that's our first argument as to why there's clearly genuine issues of material fact that were appropriate for trial. Our position is that the Shoemaker versus Community Action Organization of Scioto County decision from the 4th District is instructive in this case, because in that case, the plaintiff established in testimony that he lost his job because of the defendant's statements. And here we have evidence from school officials that I am not working for the school district right now because and only because of the defendant's statements and actions. So as we argued in the briefs, there's sort of a res ipsa loquitur argument here. We know there are additional statements made by the defendant that aren't in the record that caused someone to call the Ohio Supreme Court and file a grievance against me. Those statements have to be of a serious nature or that behavior would not have occurred. It's very unusual to ask to file an anonymous complaint against the lawyer.
But isn't that a confidential process?
It is, Your Honor, but certainly by filing a complaint against me, I was required to respond and spend several hours drafting my reply to the inquiry from the disciplinary counsel. But the fact is that the individual who filed the grievance claimed not to be the defendant, which means other people have opinions about me, negative opinions based on what she said, and those opinions were so negative that they called the Supreme Court and asked to file an anonymous grievance.
In that grievance, the people who made the grievance, did they connect that to a statement by
The grievance was, I heard it from someone who heard it from the defendant that this attorney is having an inappropriate relationship with a child.
So it was rumors, there was no connection, that it was a statement by her.
It did say it was a statement from an individual who heard it from the defendant. But again, someone calling the Supreme Court, taking the extraordinary step of requesting anonymity and filing a grievance, had to have heard something very concerning to that person. And certainly as an attorney who represents children as part of my major practice area, it's very concerning that individuals who I don't know who are requesting anonymity to file complaints about me. So the test for whether something is an opinion or not is whether it can be proven false. As we've said, we know there are statements outside of the record that the defendant made that damaged my reputation, but the statement in the record is also very instructive. In her filings, the exhibit demonstrating her email only shows that it was sent to the head speech and debate coach. In fact, it was sent to 9 different people, including the assistant chief of police, juvenile probation court officers, the superintendent, the principal, therapist here in the area. So our position is that if you email the police and use the words inappropriate relationship and minor in pretty much any order, you either know exactly what you're doing or you're reckless in failing to know. And in either of those situations, the mens rea is satisfied in this case. And so the trial court erred in granting summary judgment. As I said, there were multiple people who reported to Children's Services. This lawsuit was not filed immediately, and so it concerns me that the trial court may not have been fully familiar with the record when it made a 2-page decision with no citations.
Did they have individual affidavits submitted as well that they had reported to CSB?
I don't know that the other 2 affiants specifically said they had reported to CSB, but there were multiple people who did, and my affidavit references
Did you
that.
reference the people? Did you name the people?
No. So we live in a world, unfortunately, where gun violence and suicide are among the top killers of our children. So if a young person comes to a lawyer who is a mandated reporter and says, I am not safe in my home, I am being abused by a parent, that triggers very serious legal and moral obligations on the part of an attorney and a community member. And in researching with the Ohio Office of Disciplinary Counsel and talking to other colleagues, my actions in this case have been to discharge my moral and professional obligations to this young person to the best of my ability. And unfortunately, in standing up for an abused kid, I have lost a cherished role in the speech and debate community.
But
that I held.
doesn't your role as a mandatory reporter mean that you make a mandatory report? Isn't going further, doesn't the appellee in this case have the right to make decisions about what adults or kids are allowed to be around? And allowed to say which ones that she doesn't think are appropriate?
That's very true, and there's an underlying issue here about whether a minor can retain counsel absent parental permission. There's a judicial bypass structure here in Ohio for reproductive rights cases, which says very clearly minors can hire their own counsel, and their parents don't have to be aware of it and don't have to consent to it. So I have not admitted any of the communications that were alleged between myself and this young man because they would be privileged. And in fact, the existence of an attorney-client relationship can sometimes be privileged if it needs to be kept from an abuser. But so in this case, calling Children's Services is not enough when we know how common it is for abusers to gaslight their victims in the community. When abusers are saying, well, the victim is crazy, the victim is making this up, and other people trying to help the victim are also bad actors. That's a very common pattern we see in domestic violence cases. It's just not common that it comes from a mother. So in this case, the plaintiff, me, suffered real damages by standing up repeatedly for an abused kid and going above and beyond the call of duty in the sense that Children's Services investigation was unproductive. And in fact, this young man was taken out of the country and left with an accused child abuser while Children's Services was actively investigating the situation.
And is this in your affidavit as well?
It is, Your Honor. It's in our, yes.
At the end of the appellee's brief, she seems to request Rule 11 sanctions. Do you think we should consider that motion here?
I think that there is a Rule 11 violation on the part of the defendant in that there are multiple affidavits where she says, I didn't know that he was a speech coach. I had no knowledge of any contractual relationship. And then she also sends emails directly to school district officials saying, Brian is a coach. He is obligated to follow your rules. Her attorney himself sent a letter to the principal saying, talk to your coaching staff. Here are copies of these filings. And then her attorney later executed and notarized and filed an affidavit saying she didn't know if I was a school district employee. So her attorney could not have had a good basis to believe that she didn't know I was a school district employee, having himself sent letters to the school officials referring to me as such. I would reserve, we're not the party that requested oral argument in this case, so I would reserve the remainder of my time for rebuttal, Your Honor.
Thank you. You may proceed.
Good morning, Your Honors. May it please the court. My name is Upikin Gunawan, and I represent myself, the appellee. I'm not a lawyer, and I have no legal education at all. I'm simply a common citizen who are forced to stand here to defend myself from this frivolous lawsuit because I cannot afford to retain an attorney. Dear Mr. Hoffman, kindly be requested to stop contacting my son. It was this simple request from a single mother of a 16-year-old son.
Counsel, I'm not sure anybody, counsel, God, I'm so used to saying that, I apologize to you. The counsel on the other side is saying that I don't think he's disagreeing that you had every right to say, don't see my son, but you don't have the right to say things that are untrue about someone.
I did not say anything untrue about someone. This is why I said, dear Mr. Hoffman, kindly be requested to stop contacting my son on October 18 of 2022. It was this simple request from me, a single mother of a 16-year-old son and an 18-year-old daughter, at that time, that Mr. Hoffman chose to disregard and felt compelled to stop this litigation.
But he's talking about the email that you sent to the
I-
superintendent of schools and various other people.
So I reached out, I was referred to contact him by his supervisor, Mrs. Holly Custer, the head of the speech and debate team, who referred me when I addressed the issue with my son, whom I was hoping that she could help address because that she referred me to contact Mr. Hoffman. And in front of the school administrators and the speech coaches, I did contacted him and witnessed by all parents when we had that homecoming weekend. So, because I have exhausted all the means, I started off by approaching him, please stop contacting my son. He disregarded it, kept contacting my son. I reported it to his supervisor who referred me to contact him so that my son could probably get help because he's a teenager. So hopefully having a male talking to this young man could help mediate or reconcile our families. So unfortunately, his involvement within the span of 20 days was just making it from the homecoming weekend until his interaction with my son ended up making the relationship even worse. Therefore, I approached this from a mother, a parent, to the school, please, because he did not listen to me, he did not want to hear me, he disregarded my wish as a parent. I approached the correct path. I approached the speech coaches, who approached the school administrators to try to reinforce, please, do not have this person contacting my son. This is what happened. So, may I proceed? Thank you. Did I answer your question, Judge?
Yes, you did. I was just specifically wondering about the comments that he was having an inappropriate relationship with your son.
Again, I will address it in my thing. So,
Okay.
it was in my opinion, and it is inappropriate for a much older adult to have any personal relationship with a 16-year-old minor. As a parent, I have my children's best interest in mind at all times, and have the rights and responsibilities protected by the Constitution of the United States and firmly upheld by the United States Supreme Court to raise and care for my children to the best of my abilities. This including whom I see not fit to be around my children. So I was seeking to reinforce my request that Mr. Hoffman have no further contact with my son after previously repeatedly asked him to cease further contact with my minor son, which Mr. Hoffman chose to disregard over and over again. Contrary to what I initially asked of Mr. Hoffman to help me reconcile with my son, his involvement with my son over the span of 20 days was making the situation worse, causing me to lose the filial consortium with my son, disintegrating my family to a point of no return, making me suffer from mental and physical anguish and financial hardship due to owing a significant amount of debt resulting from ongoing litigation, counseling, medical, and health expenses. In response to my request that he cease contacting my minor son, Mr. Hoffman now claimed that as my son's attorney, a 16-year-old cannot be in any legal contract. And he told me to not contact him at all. He could not discuss any communication between him and my son. He was and is abusing his privilege as an attorney by harassing me with lawsuit, while evidently he was the one submitting false claims and statements in bad faith to this lawsuit and its amendments. For instance, I heard that you, Judge Carr, asked whether the report to the Wayne County Children's Services, when was it done? He could not recall. I had it dated here, November 14th, 5 days after the trial court issued a judgment entry stating that plaintiff will not prevail. The trial court was correct and prudent in granting summary judgment to me on all counts of Mr. Hoffman's amended complaint in his frivolous lawsuit. The findings of fact was a matter of fact that I have exhausted my effort in enforcing my request that Mr. Hoffman cease contacting my 16-year-old son, while he intentionally and persistently disregarded my request and continued interfering with my parental rights that led to the disintegration of my family. The conclusion of law was correct and prudent that this lawsuit has no merit. The evidence showed that my statement taken in context with my other communication is simply my opinion. The inappropriateness of the relationship was in regard to my belief that Mr. Hoffman was interfering with my attempts at reconciliation with my son, and Mr. Hoffman had become a bad influence in regard to issues with my son. Mr. Hoffman would have been better served to just abide by my request and have no further contact with my son. If he was concerned with my son's treatment in his home, he should have been reported these concerns to the Children's Services before doing any litigation. So these actions he did repeatedly in bad faith immediately after the court denied his motion for emergency restraining order and preliminary injunction. Mr. Hoffman's immediate filing of this lawsuit is evident to the abuse of his privilege to practice law, seeking among other monetary judgment from me. Mr. Hoffman has been the one making false statements and claims in bad faith throughout this lawsuit and its amendments. Over the course of 2 years, from October 27, 2022 to September 30th, 2024, the trial court has scheduled many hearings and conferences and generously excused his amending the lawsuit and repeated patterns of seeking extensions after extensions in most of his late filings, and opportunities he abused by adding and amending his lawsuit with misrepresentation of facts and false statements and claims that are harming, damaging, and detrimental to my character's reputation and health and well-being. Going to the law to address the assignment of errors by Mr. Hoffman, according to the Court of Appeals for the 9th Judicial District, the assignments of errors 1 through 4 are quoted, I will read it below, in Messer v. Summa Health System. And it's also listed in my page 15, 18, 23, and 27 of my brief. Summary judgment shall be rendered forthwith if the pleadings, depositions, answers to interrogatories, written admissions, affidavits, transcripts of evidence in the pending case, and written stipulations of fact, if any, timely filed in the actions show that there is no genuine issue as to any material fact, and that the moving party is entitled to judgment as a matter of law. A summary judgment shall not be rendered unless it appears from the evidence of stipulations, and only from the evidence or stipulations that reasonable minds can come to but one conclusion, and that conclusion is adverse to the party against whom the motion for summary judgment is made. That party is being entitled to have the evidence or stipulation construed most strongly in the party's favor. It's Civil Rule 56C. Appellate courts consider an appeal from summary judgment under a de novo standard of review, Grafton v. Ohio Edison Company. This court uses the same standard as the trial court applies under Civil Rule 56C, viewing the facts of the case in light most favorable to the non-moving party and resolving any doubt in favor of the non-moving party by v. Stowe Woodward. Accordingly, this court stands in the shoes of the trial court and conducts an independent review of the record. Summary judgment is proper under Civil Rule 56 when 1. No genuine issue as to any material facts exists. 2. Party moving for summary judgment is entitled to judgment as a matter of law. And 3. Viewing the evidence most strongly in favor of the non-moving party, reasonable minds can only reach one conclusion, and that conclusion is adverse to the non-moving party. Another case, Temple v. Wynn United Incorporated. It's explained by the Court of Appeals for the 9th Judicial District in Fisher v. Hoffman. An action of defamation requires proof of 5 elements: that a false statement of fact was made, that the statement was defamatory, that the statement was published, that the plaintiff suffered injury as proximate results of publication, and that the defendant acted with the requisite degree of fault in publishing the statement. I, as a mother, reached out to the school administrator, to the head coaches, tried to reach out to the party involved first, to Mr. Hoffman himself, before reaching out to his supervisor, going up the chain to the school administrator, trying to address these issues, to resolve it. It's just as simple as, please stop contacting my son, that's it. The fundamental element of a claim for defamation is false statement of fact. It's axiomatic that a statement of opinion is not a statement of fact. Here, Mr. Hoffman claimed, I'm liable for defamation, per se, per quote, and slander, for the statement in my email of October 21st, 2022, that it is inappropriate for an adult, in parentheses, I'm guessing he's between 39 and 40 years old, to have any personal relationship with a 16-year-old minor. However,
Is that also a true statement? He's not a relative, he is a person in authority, so
he's a
is
total
it
stranger
inappropriate, saying it's inappropriate in that context, is it actually false?
In general, Your Honor, as a mother, I'm protecting my children. They are minors. I will be very uncomfortable, and especially because we have incidents where Mr. Hoffman asked 3 times. When I was seeking out for help, he came to the house and he asked for 3 times. I think it's best for your son to stay with me tonight.
Yeah, did you put that in an affidavit?
Yes.
That he
Yes,
asked
it was
for
on
overnight?
record.
Nice. And for other personal type of, like dinners and things like that?
Yes, all are in my affidavit. It's chronologically ordered and also in my brief, how that facts unfolded.
Is that in violation of school policy?
To my understanding, for my daughter and my children, who my son was also in soccer, their coaches cannot transport their children to anywhere without a waiver, and it has to be on a school bus, not on personal vehicle. And I also mentioned in my affidavit and also in my brief the chronological account, and I noted and witnessed by my daughter that my son has been transported in Mr. Hoffman's personal vehicle outside of school near our house in our neighborhood multiple times, and it's also on record. Did I answer your question?
Yes,
Or-
thank you.
Thank you. So except for my affidavit of August 5th at paragraph 16 and 7, that was and is my opinion in it. And indeed, that opinion is likely shared by many people, particularly when the 39 to 40-year-old adult has been told repeatedly, stop contacting my minor son by the minor's parents. Regardless, my statement is simply not a statement of fact, but it is not untrue because it happened. Even the statement were a statement of fact, it is not a false statement in the context of this case. I am my son's mother. I repeatedly asked, requested, instructed Mr. Hoffman not to have contact with my 16-year-old son then. He continually disregarded my wish.
And you're out of time, so if you could wrap up in about 15 seconds.
Sure. Thank you, Your Honor. If I may conclude, that this is a frivolous lawsuit. As a natural mother of my son and sole legal custodian of my children, I was exercising my parental rights and responsibilities to raise and care for my children. And it's also keeping my children's best interests in mind, which rights and responsibilities are protected by the Constitution. Contrary to what Mr. Hoffman was being asked in the first place to help me reconcile with my minor son, he was audacious, egregious, and nefarious in his continuous, intrusive, and impetuous interference with parental rights and responsibilities. He has abused the privilege to practice law in Ohio bestowed upon him by the Supreme Court of Ohio by abusing the justice system and using the law to disintegrate, harass, harm me and my children, citizens of the United States. Dissatisfied with the judgment entry, he denied his motion. He used children's services as his tool. For all the foregoing reasons, the trial court was correct, and as grounds, there are no genuine issues as to any material facts, and I'm entitled to judgment as a matter of law. I respectfully move this court to affirm and uphold the decision of the trial court and dismiss Mr. Hoffman's appeal. I also plead this court to order Mr. Hoffman.
I can't, you're way over your time, so if you could just wrap up.
Yes, please.
With the sentence, wrap up with one sentence.
Yes. I plead the court to order Mr. Hoffman to compensate me for all my attorney fees, court fees, etc.
Right, that's one sentence, sorry. Thank you. You have to have a seat. Thank you.
Thank you. Thank you, Honor.
You have your full 5 minutes for rebuttal.
Thank you, Your Honor. So, the defendant in this case, in oral argument, has made reference to a variety of facts which are still in controversy. In the context of the pleadings, we denied any ongoing continued communications with the defendant's son because if they existed, they would be privileged and confidential. So the issue of whether I was still communicating with her son and if those communications would be covered by attorney-client privilege is an unresolved factual issue that the trial court overlooked.
What is the statute you're referring to about the bypass?
The judicial bypass issue is briefed in one of my prior filings. I don't know the statutory.
Okay, you're talking about something different other than the reproductive statute.
In a situation where a minor wants to terminate a pregnancy without parental permission, they can hire an attorney.
Yes, and I'm
attorney.
saying, are you referring to one different than that?
No, but that particular statute simply says that a minor can notify the court if she has counsel. So there's nothing.
But that's very narrow. That's in the context of a pregnant minor who has a certain kind of situation that may want to bypass the parents for safety reasons. So how does that relate to this case? Isn't it just a true fact of the law that minors cannot contract without parental, for an attorney without a parent involved?
No, Your Honor, we disagree. So the General Assembly.
So what's the law for that? Where do we find that?
So there is a general right, if you look to the Ohio Rules of Professional Conduct, there are lots of rules providing for the representation of minors. There's a general statute about those under 18 being under a disability, but there's nothing that says minors can't hire their own counsel.
They do, there are contexts where you can hire your own counsel as a minor. It usually comes in the context of parental rights already being severed in some form.
So it's an open factual question in this case.
But what other context, when there's no other involvement with CSB or a pregnant teenager, how would you have the authority to be this minor's attorney?
So in the judicial bypass statute, the General Assembly doesn't say there is created a special right for the purposes of this statute only that minors can hire counsel. It just says minors can notify the court if they have their own counsel. And since judicial bypass is only necessary without parental involvement, it's necessarily an attorney-client relationship that the parent wouldn't have
So
consented to.
she's asserted in an affidavit that you asked for overnights with her child.
And we disputed that in our affidavit.
And that's what I'm asking, you disputed that. You said that was never, you said you just had attorney-client privilege, or did you say that never happened?
No, we said that did not happen as she described it. She was attempting to send her son to Boy Scout target practice with guns after taking the bedroom door off his room and claiming he was on suicide watch. So we offered an alternative location for him to spend the night so that she wouldn't call the police on him or expose him to firearms. She then turned that into a request for him to come spend the night with me, which is not at all what happened. But again, that's a contested issue of fact that the trial court did not resolve. In her affidavits on the beginning couple weeks of October, she invited me into her home. She asked me to stay for dinner. She sent her son to an out-of-town professional fundraiser with other attorneys and me. So it was only after she reached the conclusion that I was not agreeing with her agenda that she emailed people saying that it was inappropriate for a personal relationship to exist between an adult and a minor.
Did she first ask you to cease contact with her son?
She did. That email is in the
Right.
record. At that point, based on my conversations with the Ohio Office of Disciplinary Counsel, I was not able to disclose whether I did have ongoing communications with her son, because if an attorney-client relationship existed, it would have been, the relationship itself would have been privileged.
Counsel, how do you respond to the appellee's argument about you should have reported to CSB
We did, and we did so multiple times, not just the reference that the defendants made.
earlier?
So the initial report, I'm looking through my affidavits, I think it was the first week of October of 2022. So we did report timely as the mandatory reporter statute requires, and there was more than one report to CDP during the course of this case. So some of the statements, including factual statements that the court has heard the defendant make just now in oral argument, are actively disputed by the parties and were not addressed by the trial court. The defendant has not denied that she lied to her son about bringing him back for a prestigious national tournament. She's not denied that she lied to him about why his dad wasn't in his life. She's not denied that she lied to the school that she was going to bring him back in time for the tournament. And so the fact that only after she formed opinions about me, she decided to express this opinion about relationships between adults and minors, is the timing of that is enough to show that we prevail, at least on our claims for defamation per quad. If I were to email Chief Justice Kennedy and say, Chief Justice, it's inappropriate for a panel of the 9th District Court of Appeals to have relationships with litigants, that wouldn't just be expressing a general opinion, it would be making a statement that such a relationship exists. There's no reason to send emails like that unless you're making underlying factual assertions. But again, there are statements beyond what's in the record that were not discovered. The trial court didn't extend time for discovery like we asked it. But with that, we would ask the court to remand for a trial on the factual issues. Thank you, Your Honor.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are also posted on the Ohio Supreme Court website. Thank you again. At this time, the court is adjourned.